Moi has been brought before this court pursuant to warrant of arrest issued against him following the grant of the application made by the plaintiff decree holder by way of notice of motion dated 24th January 2024. For clarity, this is what the application sought. Prayer A was spent. B, that summons do issued to Collins Kibet Turoitich Moi, being the respondent, to personally appear in court and show cause why he should not be committed to civil jail for contempt of court for a period of 6 months. C, that the court be pleased to find that Collins Kibet Turoitich Moi is in contempt of the court order or decree issued on 2nd of June 2022, sorry. D, that the court be pleased to grant orders for arrest and detention of Collins Kibet Turoitich Moi, cited above, in person for a term not exceeding 6 months. And E, that this court be pleased to order the defendant to refund the applicant a sum of 2,200,000 spent on school fees, medical needs, and entertainment. The application was supported by the affidavit sworn by the then applicant, Gladys Kipkorir Tagi. I deem it fair to also look at the decree referred to in that application. This is the extracted decree from the judgment of the court. 1, that the defendant shall pay school fees and also take care of the medical needs for the minors via an annual medical cover. 2, the parties shall share in the provision of entertainment needs of the minors. 3, that the mother is ordered to provide for the rest of the needs of the minors. And 4, that each party bears on cost. That is the summary. Sorry, that is in summary the issues giving rise to the events of this morning when Collins Kibet Turoitich Moi was brought before me. Mr. Musili from Anthony Musili and Company Advocate appeared for the defendant judgment data. He came in after filing a notice of appointment of advocates this morning. This being a children matter, I overlooked the strict provision of Order 9 of the Civil Procedure Rules and discretionally granted the said counsel leave to come on record for the defendant without the requirement of putting in a substantive application for leave, considering that is coming on record post judgment. Mr. Musili, though not in clear terms, sought for the lifting of the warrants and also asked for time to familiarize himself with the file, which I must admit is quite voluminous. He made no clear attempt towards the satisfaction of the decree other than stating that the judgment debtor is not a person of means. Mrs. Mukira had this to say, that there is a judgment of the court that has given rise to a decree that is yet to be satisfied. She submitted that the plaintiff filed an application for contempt, which led to granting of the warrants of arrest, leading to the arrest of the defendant, the judgment debtor. She urged that unless the decree is satisfied, the defendant should be committed to civil jail until such time that he satisfies the decree. I have considered the heavy and lengthy oral submissions by the parties, and these are the salient and disputed facts. A, that there is a judgment against the defendant that was delivered by my predecessor, Honorable B. Limo, on the 2nd of June 2022. B, that there is a decree duly extracted as per the judgment in A above. C, that there is an application dated 24 January 2024 referred to in the 4 of this ruling. D, that arising from the application, this court issued a notice to show cause upon the defendant to show cause why he should not be committed to civil jail. E, that the notice to show cause was duly served upon the defendant and warrants of arrest against the defendant were issued on 27th of March 2024. F, that this matter has been mentioned on several occasions to confirm execution of the warrants. G, that the warrants of arrest was finally executed and the defendant judgment data is now in court. My duty, therefore, is simply to assess and determine if the defendant judgment data has shown proper cause to warrant discharge of the enforced warrant. Of importance to note is that even in the absence of the defendant in person, there was a counsel on record, Mr. Mutai, who has been appearing for the defendant. My respectful view in the circumstances is this: there is a valid judgment on record that has neither been reviewed or set aside or even appealed against. The said judgment has been executed. The defendant decree holder has not given any proposal as to how he is going to satisfy the decree. No proposal has been advanced to this for this court's consideration. In the absence of a logical proposal of satisfaction of a valid judgment, and considering that the execution process is lawful, I shall proceed to enforce the execution. I, however, note one thing. I know that the decree does not provide any tabulation of the sum currently owing. Consequent thereto, I direct that the decree holder do tabulate the exact sum owing as per the decree as at this date and serve upon the judgment data within 3 days of today. I shall mention the matter herein in 7 days to get the exact sum owing towards the satisfaction of the decree. In the meantime, the judgment data shall be committed to civil jail for the period, and the decree holder shall pay the judgment data's subsistence for the period. The matter shall be mentioned on 26th of September 2024. I hereby issue production order for the judgment data's production in court on that day. That is the ruling of this court. That's all. Thank you.